Here are a few things you never want to put in your last will and testament. First thing is, if you have a business, the business should never go in your will because the business will need to go through probate. And as you guys have heard me say before, probate is a sucker's game that just makes lawyers money. I should know, I do it as part of my practice. But it is never in my client's best interest to go through probate. It is in their best interest to create usually a trust and avoid the entire probate process altogether. But getting back to your business, you certainly don't want your business operations to cease while it is subject to the court's calendar, which takes forever. In Florida, probate can take easily 6 to 12 months. During that time, your assets are often frozen. There's no one to write paychecks for your employees, so they're going to go get another job. There's no one to pay rent or mortgage on your commercial building or the space that you run your business out of. And so for that reason, you don't want your business to go through probate. You should see a qualified attorney that can set up a business succession plan for you, and that will work out much better. Another thing is, if you have any minor children, you should always utilize a contingent minors trust versus just leaving assets in your will directly to a minor child. It definitely increases the efficiency of the process when you use a trust over a will. If you have a special needs beneficiary or a beneficiary who has an addiction like drugs, alcohol, or gambling or anything else that would make it a bad idea to just hand them money, whether that would result in a loss of government benefits or whether that could be more problematic. For instance, giving someone who has a drug problem a large sum of money at one time could be very problematic. That's another place where we can use special needs trust or discretionary trust in order to accomplish that goal. And finally, for those of you who have more than one piece of property, or honestly, even for your home, you don't want your home to go through probate, but you certainly do not want to go additional properties go through the probate process. So if you have rental properties, commercial properties, vacation properties, all of those should most likely be in protective structures so that if you get sued or someone gets hurt on the property, you have asset protection and anonymity. But ultimately, when you pass away, you don't want those assets going through probate. Remember, the probate attorney typically gets 3% of your probate assets. And that can start to become a pretty large figure for someone that has $1 million estate. That's a $30,000 statutory attorney fee that can be avoided through proper trust planning. If you want to know more about this, give us a call. Our consultations are always free. Happy to sit down to talk to you, look at your situation, and lay out a plan of why you're going to want a trust over a will. Thank you so much. Have a great day.